3, 2, 1.
Oh, yay, oh, yay, oh, yay. This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner. Good morning, ladies and gentlemen, and welcome to the March 31st oral argument docket of the Tennessee Supreme Court. As we have been doing for a number of months now, we are continuing to do our oral arguments by Zoom and having them live streamed on YouTube at the same time. Because of the pandemic, we have been able to utilize this mechanism to keep our dockets current and to be able to continue to have our court system open. That's been a very critical component of our court's approach to the COVID pandemic, because we feel it's so important to protect the constitutional rights. And even though in-person proceedings may be limited, it's very important for us to continue to have an open court system to deal with those immediate needs that are out there. As I say, we have continued to do this for a number of months now. We have found it to be a very good substitute for the in-person oral arguments. In just a moment, we'll begin our one case that we only have one case on the actual oral argument docket today. In just a moment, we'll begin that case. We also want to specifically welcome those of you that are watching on YouTube. And we thank you for your interest in the judicial system in Tennessee, and hope that you will find this an informative process and be able to see what is happening and to understand better our justice system in this state. When we do begin in just a moment, each side will have 30 minutes to present their argument. If the appellant wishes to reserve any time for rebuttal, please do so at the beginning of your argument. And after that, we will proceed to dismiss our court. So, Mr. Hibner, if you will call our case today, please.
State of Tennessee versus Jeremy Reynolds.
All right. Counsel for the appellant ready?
Yes, Your Honor.
Okay. All right, you may proceed.
May it please the court, Catherine Redding on behalf of the state, I'd like to reserve 5 minutes for rebuttal.
All right.
A jury found the defendant guilty beyond a reasonable doubt of first-degree premeditated murder. But when the Court of Criminal Appeals considered the defendant's conviction, it ignored this court's directives regarding appellate review. First, although the state has presented compelling circumstantial evidence which supports the jury's verdict, the Court of Criminal Appeals reversed the defendant's conviction by disregarding both the standard of review for sufficiency claims and the proof presented at trial. And second, although the Court of Criminal Appeals upheld the admission of all of the 404B evidence challenged by the defendant in his appellate brief, the court remanded for a new hearing based on evidentiary issues the defendant neither raised nor preserved for appeal. Because the Court of Criminal Appeals disregarded the standards of review applicable in this case, this court should reverse its decision and uphold the jury's decision to convict the defendant of first-degree premeditated murder. The Court of Criminal Appeals did not apply the correct standard of review in reversing the defendant's conviction. When the court concluded that the evidence was insufficient to prove premeditation, it did so by ignoring this court's directives as to the standard review for sufficiency claims. I'm aware that this court has read the briefs and is familiar with the facts, but because this claim relates to sufficiency, I'd like to briefly address the key facts presented at trial. Shortly after the victim returned home for the evening, there was a confrontation on his front porch. During that confrontation, the victim was shot 7 times, sustained a contact wound to his chest and 6 wounds to his back, at the back of his body as he attempted to flee inside his home. The victim was, however, able to fire 2 shots of his own at his attackers. Although there were no eyewitnesses to the shooting, witnesses reported that they saw a light-colored Mitsubishi SUV driving away from the scene, and approximately 8 minutes after the first 911 call, the defendant arrived at the nearby hospital in a vehicle matching that description. The defendant, who had sustained a contact wound to his side, was carried into the hospital by a man named Dewante Duncan and an unknown individual. The bullet removed from the defendant's side during surgery was the same kind as the bullets fired by the victim's gun and was likely fired by a Glock, which was the same kind of weapon that the victim had. Approximately 3 months after the murder, the .45 caliber high-point pistol used to kill the victim was found in the possession of an individual named Gerald Jackson. As the defendant has conceded multiple times at the trial court, the Court of Criminal Appeals, and here today, his only connection to Mr. Jackson was their mutual membership in the Gangster Disciples street gang, of which Mr. Duncan was also a member. When the proper standard of review is applied and all of the evidence is viewed in the light most favorable to the state, as it must be upon conviction, the proof amply supports the jury's finding that the defendant acted with premeditation when he shot and killed the victim. A jury could reasonably infer that the defendant expected and perhaps sought out a confrontation with the victim from the fact that the defendant went to the victim's home with 2 companions and at least 2 firearms. The defendant decided to be armed when he went onto the victim's porch, and in the light most favorable to the state, this is evidence of planning. A jury could reasonably infer that the defendant and his companions were lying in wait from the victim based on the timing of this offense and the fact that the victim was shot within moments of returning home and reaching his front porch. The victim sustained a contact wound to the chest. A jury could reasonably infer that the shooter in that situation made a deliberate choice to put his gun up to the victim's chest with the gun in contact with his body and fire the trigger. The jury could also reasonably identify the defendant as the individual who inflicted this wound based on the ballistics proof that was presented at trial regarding the defendant's own wound. The defendant and his companions used at least 2 firearms in quick succession to shoot the victim, and the defendant and his companions shot the victim 7 times, repeatedly shot the victim in the back, and did so as he was attempting to flee inside of his home. And when the confrontation ended, the defendant failed to render aid to the wounded victim. And from these facts, a rational trier of fact could have found that the defendant acted with premeditation. But even if the proof was not sufficient to show that the defendant personally acted with premeditation, it was still sufficient for a rational trier of fact to find the defendant guilty of premeditated murder under the theory of criminal responsibility. The defendant accompanied his associates to the victim's residence while they had at least 2 weapons. He stayed with his companions while they waited for the victim to return home. He accompanied at least one of his companions onto the victim's front porch. He got close enough to the victim during this confrontation that the victim was able to put a gun against his side and pull the trigger. And the defendant was part of the group that abandoned the victim on his front porch without rendering aid. So even if the jury declined to find that the defendant pulled the trigger or that he acted with premeditation, it could have reasonably concluded that his companions acted with premeditation and that the defendant, acting with the intent to promote or assist in that offense, the commission of that offense, aided or attempted to aid his companions in committing the offense. And that is enough to sustain a conviction for first-degree premeditated murder.
Ms. Redding, this is Justice Clark, and you've taken some time now to recite for us the evidence that you think together is sufficient. I just want to be sure and clarify, because do you agree that in this case, there were certain things not in evidence, and every one of them is not required, but we more often see them in cases like this? There was no eyewitness testimony about the defendant stating anything that would have shown premeditation. Is that right?
Correct.
And there were no prior statements of any intent to kill the victim. And there's not really a lot of evidence about whatever planning about this offense may have gone on before the arrival at the place. And I'm not suggesting that any one of those is absolutely required, but I just want to be sure that we are looking not only at what is there, but what is not there that might be.
Yes, Your Honor, that's correct. Unfortunately, this is not a case where there were witnesses who could testify about what happened prior to the shooting. The proof was limited to what happened once the victim arrived.
Right. Thank you.
Ms. Redding, this is Justice Page. Would you concede that the proof of premeditation here and whether it should be upheld by an appellate court is a close call?
I'd say that this is, the case here was circumstantial. I think that there are several factors that a reviewing court could find, or that a rational juror could have relied on when finding premeditation. I think that the issue here is the Court of Criminal Appeals did not consider all of the evidence that was presented at trial and did not consider all of the evidence that was presented in the light most favorable to the state.
And those are the two biggest reasons that you feel like you should win on this portion of your appeal, correct?
Yeah.
Do you feel like the fact that all the evidence of gang activity could have tainted the jury's deliberation with respect to premeditation?
No.
Well, didn't we have one juror that got so upset about all the discussions of gang activity? At least we can infer that from the record that she had to be replaced by an alternate.
So the facts about the juror who had to be replaced actually show that after these.
Well, didn't she say, I don't feel safe, I'm afraid for my children?
She did say that. So it's important to understand the context of how this came up. This was after the state's proof and after the state's last witness, who was the medical examiner. This was before the Momon hearing, before deliberations, before closing arguments. And this juror, all she said was that she had anxiety about the case. She did say that she was afraid for her children, but she did not specifically reference anything about the gang evidence. And
isn't that because the trial court did not inquire into that area? She was not asked about why she was afraid, was she?
I don't recall that the trial court specifically asked her, "Are you afraid because of the gang evidence?" But I think it's interesting that the juror expressed this concern after the medical examiner testified, and after, the evidence of the victim being shot 7 times and viewing photographs of his wounds. So I think that given the proof, all we have is that the juror was, she was upset. She said she also was having some digestive issues, so there was a combination of factors there. But the jury was polled. The trial court did ask all of the jurors, and all of the jurors who remained on the panel and went to deliberation said that they could be fair and impartial jurors.
This is Justice Kirby, Ms. Redding. I don't want to hijack your argument, but I am quite interested in the issue presented on the gang evidence.
Sure. If this court doesn't have any further questions, then we'll move on to the gang evidence. The Court of Criminal Appeals exceeded the scope of review by reversing and remanding on a new trial based on unpreserved and unraised evidentiary issues. Contrary to the defendant's claim, he did not preserve or raise for appellate review Investigator Penny's testimony about the history of the gangster disciples in its hand time, or Detective Early's testimony about the 2 unrelated robberies that were allegedly committed by Mr. Jackson. First, the defendant waived appellate review of this testimony by failing to contemporaneously object. The defendant did not object to Detective Early's testimony at trial, nor did the defendant, as the Court of Criminal Appeals acknowledged, lodge a specific objection to the breadth of Investigator Penny's testimony at trial.
This is Justice Kirby, Ms. Redding. Let me question you about that a little bit. The defense counsel did quite consistently raise the issue of gang evidence, right? Motion in limine and after the trial, motion for new trial. And it was a very broad objection to all of the evidence related to gang activity. I'd like you to address that. He may not have sussed out the distinction between this kind of evidence related to the gangs and this kind of, but the broad objection certainly would have encompassed the segment of the gang evidence that you're talking about. So I'd like you to address that issue.
So state acknowledges that the defendant did file a motion in limine to exclude gang evidence, but that motion did not serve as a contemporaneous objection. The motion asked the court to disallow any testimony in relation to gangs or gang activity, just arguing that it would inflame the jury and that it would serve no purpose. But because the motion, as the court seems to note, that it was particularly broad, it did not address the breadth of Investigator Penny's testimony. And then as a result, the defendant was required to object when that testimony was offered at trial.
Why is that? Why is that? And what standard should we use when a very broad, if certainly the motion in limine that was submitted would have encompassed the evidence that you and I are talking about. So tell me what standard we should use where a broad objection is made that encompasses the evidence that's now in dispute, but is not narrowed to it.
I think that when there is a motion in limine that is as broad as the defendant's was here, the defendant, and this, I believe it's this court, has said that the defendant runs the risk of waiving it by not later objecting to testimony that because of the breadth of the motion was not specifically addressed. And so if you look at the motion in limine hearing, the state said that it was intending to introduce evidence showing that the defendant, Devontae Duncan and Gerald Jackson, were members of the Gangster Disciples. So that is really what the motion in limine addressed. That is what the trial court.
The motion encompassed everything related to gangs and gang activity. And that's part of, I mean, certainly the evidence that you and I are talking about relates to that. So tell me again, you're telling me that he ran the risk, but you're asking us to hold absolutely that it was waived. So what standard do we use and what case law do you rely on for that?
I have relied on the case law addressing the motion in limine and the breadth and running the risk, but also on the case law regarding motions for new trial. So the defendant did file this very broad motion in limine.
Well, excuse me, Ms. Redding, this is Justice Bivens, but he also renewed that objection and asked for reconsideration of it at the beginning of the trial, did he not?
He did. And he asked, so his motion for reconsideration was based, I think, on recent news reports and just a general concern about recent press regarding gangs and that being problematic at trial. But the state's also relied on the defendant's failure to challenge the admission of Investigator Penny's testimony in his motion for new trial. And the case law on the motion for new trials is very straightforward. It says that you have to raise issues with specificity, you have to identify exactly what testimony or what evidence you're discussing so that the trial court can be certain that it addresses these issues that are raised in the motion for new trial. And so that appellate courts are able to identify and determine whether the issues were addressed in the trial court. And so the issue we have here is, yes, the defendant did file a very broad motion in limine that did touch on all gang evidence, but the trial court's ruling at the motion in limine hearing did not. It only touched on the proof of the defendant, Mr. Duncan, and Jackson's gang membership. But then we also have in the motion in limine, we do not have any specific references to Investigator Penny's testimony about the origins of the Gangster Disciples and its hand signs, such that the trial court would know that that is what the defendant was complaining about, such that it is specifically identified for consideration. We also have the defendant failing to identify either Detective Early's testimony or the breadth of Investigator Penny's testimony as issues in his appellate brief. So even if this court were to find that the motion in limine, because of its breadth, was broad enough and did encompass Investigator Penny's testimony, there's still the issue of the motion for new trial. And then there is the issue of the defendant failing to raise this issue, either Investigator Penny's testimony or Detective Early's testimony in his appellate brief. And although the defendant did raise several 404B claims in his brief, he did not identify the scope of Investigator Penny's testimony as an issue.
Ms. Redding, this is Justice Page. We can still apply plain error review if we decide to do so, correct?
Yes, and that is the state's position. The state's argument is that the Court of Criminal Appeals, because of the defendant's failure to preserve or raise the issues, was bound to consider for plain error, but instead indulged in plenary review. And as a result, it did not consider the plain error factors, and it certainly didn't consider whether any plain error from this testimony was of such great magnitude that it probably changed the outcome of the trial. And had the Court of Criminal Appeals reviewed for plain error as it should have, it would have concluded that the defendant was not entitled to relief from the admission of this testimony. The defendant would not have been able to show the breach of a clear and unequivocal rule of law. Contrary to the defendant's claim in his responsive brief, the trial court did not abuse its discretion in admitting the gang validation form or abuse its discretion in admitting the gang photographs into evidence.
Ms. Redding, this is Justice Bivens again. If we were to determine that plenary review was appropriate in this case, let me rephrase that. Is the determination of whether it's plenary review or plain error review determinative in this case?
I believe this court needs to decide whether the Court of Criminal Appeals erred in applying plenary review.
Well, now my question is, do you get one result under plenary review, but a different result under plain error review?
I don't believe so. I think the issue is if the court were to find that plenary review was appropriate, then a harmless error analysis would have to be conducted. And part of the issue with the Court of Criminal Appeals decision is that when it considered Investigator Penny's testimony, it did not apply the appropriate harmless error analysis. It didn't look at the appropriate, properly admitted testimony and then consider Investigator Penny's testimony. It simply decided that it was improperly admitted, partially because that it was not harmless, because of its unfounded error that the jury, by finding evidence of premeditation, must have just ignored the trial court's limiting instructions about gang evidence. And as to Detective Early's testimony, the court failed to consider any harmless error analysis. So I don't think that the court would reach a different result should it find the plenary review was appropriate, because when we look at what this testimony actually consisted of, I don't think that Investigator Penny's testimony, that the jury found the defendant guilty based on the background information that Investigator Penny provided, or that the jury found the defendant guilty based on this information that Detective Early presented. It really wasn't central to the case. It wasn't inflammatory, and it wasn't damaging to the defendant. I mean, there's no suggestion that the defendant was involved in the robberies, and the details of the robberies were only prejudicial to Mr. Jackson, who's the person who was alleged to have participated in the robberies. So no, to answer your question, I don't believe that we would reach I don't believe this court would reach, I don't think it's determinative of the outcome.
Ms. Redding, this is Justice Page. Should we consider at all what the prosecutor said in his closing argument with respect to gang activity and making them stop?
So I'll just note that the closing arguments were not raised in the Court of Criminal Appeals or here as an issue. But I think that looking back at the closing argument, the state's argument was really just to look at the proof. The only reference in the initial closing argument to the gang evidence was to remind the jury that the only evidence connecting the defendant to Mr. Duncan and Mr. Jackson, and thus the pistol, was their mutual membership in the gang. The defendant his closing argument went into much further detail and suggested that the state the only proof, basically that the state wanted the jury to convict the defendant based solely on the fact that he was in a gang. So I think that looking at the state's rebuttal argument, the state did mention the defendant's gang activity, but it did so in the context of what the jury's responsibility to look at all of the evidence, to consider the defendant's actions, and to reach its determination based on the proof presented at trial. And
well, it kept, this is Justice Kirby. He kept calling him Sleepy, right? Kept calling him by his gang name. So that's not subtle.
I believe that the prosecutor referred to him by Sleepy twice, maybe 3 times. in the course of its closing argument, but I think that the majority of the state's argument focused on the proof, asked the jury to reach its decision based on the evidence that was presented at trial. And the evidence that the state focused on was really the proof about what the defendant did, about premeditation. It really did not go into the gang evidence. But I think as the Court of Criminal Appeals concluded that even if that closing argument, there were some improper portions of the closing argument, it wasn't so improper as to be to rise to the level of plain error. So I don't think that the defendant would be entitled to relief due to the closing argument, given that it's not, given that it would be reviewed for plain error.
Well, this is Justice Lee. Do you agree that the state at trial did more with the gang evidence and gang argument than they needed to do?
I think
As
certain,
calling him sleepy and using a gang name. I mean, it seems a little overkill at some point.
I don't think that it was necessary to call the defendant sleepy. I think that the jury was aware of, was fully aware of the proof. I'd have to look back at the closing argument, but I think that the state actually used sleepy. So the photograph that the defendant had posted onto Facebook where he referred to himself as sleepy, I believe the caption was "all eyes on sleepy," and the state was trying to use that, refer back to that photograph to say, well, your eyes are all on the defendant, and called him by sleepy. So I think that perhaps it was not necessary, but it was a rhetorical presentation there. But because the Court of Criminal Appeals disregarded the standard of review for sufficiency analysis and for sua sponte review of evidentiary issues, and it could not have remanded for a new trial had it employed the required plain error analysis, this court should reverse. If there are no further questions, I'll reserve my remaining time for rebuttal.
Thank you, Ms. Redding. Mr. McDougall?
Yes, good morning to the Justices of the Supreme Court. My name is John McDougall, and I'm arguing for Jeremy Reynolds. Your Honor, one of the things that had surprised me about this is that the state did not bring this up in front of the Criminal Court of Appeals, that I had waived the issues. The only one that they had said that I had waived was something about a photograph, which I don't think I waived either. To go ahead and go back to what counsel had stated, the objection, I mean, we did the motion in limine, the objections were raised at the proper time. One of the reasons we do the motion in limine is so I'm not standing up and constantly objecting if the court's already ruled on it. There was nothing changed. We had actually argued the entire thing as to all the gang evidence. We had argued whether or not Mr. Penny could go ahead and testify. The judge had determined that he could go ahead and testify, so that was already determined. It was already determined that all the gang photographs, because the photographs were brought in at the motion in limine, and the judge had already ruled on that. The judge had ruled on all the gang activity that we wanted to go ahead and keep out because we wanted this to be about the facts of the case. And the facts of the case were that never did they show anything that Mr. Reynolds had done. Basically, what in the light most favorable to the state is they can show that he was shot. The state may have been able to go ahead and prove that the defendant was there at the but not. But we were arguing that even then, the expert for the gun testimony couldn't go ahead and say it came from the same gun that the victim, Mr. Washington, had. And they couldn't show that Mr. Reynolds had instructed somebody, had planned with somebody, had done anything to go ahead and plan this murder. That was one of the biggest arguments that we had. What the state did have and what they did use is 404, basically character evidence. They essentially brought in the gangs. They brought in the fact that Mr. Reynolds was a gang, even though we never brought in the fact that of anything as to Mr. Reynolds' character. The state was the one that brought that in, and they basically said they were going to prove it. We had a long hearing as to what the state could bring in, and the judge allowed most of it to go ahead and come in, much to the detriment of Mr. Reynolds.
Mr.
Mr.
McDougall, this is Justice Clark, and I just want to be sure I understand. Are you arguing today still that the evidence doesn't prove his identity as the perpetrator? He's
I would
talking
state
about
that,
the
yes, Your Honor.
sufficiency of premeditation.
Right. Well, I mean, we're arguing premeditation, but we're also arguing to go ahead and I'm responding to Ms. Redding. There's nothing to show. For example, she says, well, they lied in wait. There's no proof of that. She argued before the Criminal Court of Appeals that, well, he failed to give aid when there's no proof of that, and the Court of Criminal Appeals addressed that.
Mr. McDougall, this is Justice, let me interrupt you a second here. On page 21 of the state's brief in this court, I'll give you a second to get there. At the bottom, the last paragraph, there's 7 factors that the state sets forth as showing premeditation. I would like you to respond to those.
Okay, let's see. That's the state. Okay, this was the Supreme. You're talking about the state's brief to the courts?
Yeah.
To the
Is it on
Supreme
page
Court,
21?
yes. The one we have here before us.
Okay, that's what I'm. And I'm looking and I don't see, let's see, I see failed to waive his claim alleging that the state committed a Brady violation. This is on page 21. Perhaps I have the wrong.
You're on a different brief. This would be the one, their brief they filed in this court, not the Rule 11, but the appellate brief.
Oh, okay. Let me check and see. I apologize to the court. I'm trying to find the correct brief here. So let's see. That's page 21. Okay, here it is.
Begins here by contrast, et cetera, and it's got 7 factors listed there.
The planning the activity. Am I correct? Is that the one we're looking at? John?
It's number
Yeah,
1.
first off, it's planning the activity, the shooter's acceptance of the loaded weapon. There's nothing to show that any of the activity was planned. Basically, the evidence that was at trial was that the witness stated that that Mr. Washington came up to the porch, looked out, saw somebody close the door. She heard argument and then heard shooting. She did not see Mr. Reynolds. She didn't see anybody, nor did the defendant's mother, who also testified.
But Mr. McDougall, this is Justice Lee. Couldn't a rational juror decide that it just wasn't coincidence that these men showed up, or this defendant showed up with a weapon on the front porch of this man's house? There had to be some coordination to get the defendant and his colleague there with loaded guns, apparently very near the porch. Wouldn't you agree that is a reasonable conclusion from just how this went down? Well,
my response to that, Your Honor, is the fact there was nothing to show that Mr. Reynolds was armed. There was none of the guns. Like I said, the gun that ended up doing the shooting.
Somebody was armed because this man got shot 7 times.
That's correct, Your Honor. Somebody was armed. Mr. Washington was killed. There's no doubt about that.
Okay. Excuse me, this is Justice Kirby. Wasn't there ballistic evidence showing close range shots?
The evidence from the autopsy showed that the person that Mr. Washington, the victim in this case, was shot at close range. It does not say who shot him at close range, who told them to shoot at close range.
But your client was the one who ended up with bullets from the victim's gun in him.
The TBI expert could not go ahead and say it came from the gun. They could say it came from the same type of gun. That's what they were able to go ahead and testify to. Well, and even then, if the defendant was shot, it does not necessarily mean he's the one that shot Mr. Washington or had Mr. Washington shot.
Well, Mr. McDougall, this is Justice Bivens. What about a theory of criminal responsibility at that point?
But for co-responsibility, Your Honor, for
Criminal
example,
responsibility, yes.
right, they can't go ahead and show indeed what Mr. Reynolds' mere presence is not enough to go ahead and say he's responsible. They would have to show that he was somehow created it, that he somehow participated in it. And in this case, they couldn't show that. All they could show is that he was shocked.
So being there with two other men with at least two weapons is not that a rational juror couldn't conclude that was participation?
I would submit to the court that they would have to show that there's something a bit more. Just being there with them is not enough. I mean, they would have to show.
Are you saying to us, Mr. McDougall, that the only logical inference is that your client was there to rescue Mr. Washington? And
Absolutely not, Your Honor.
Okay.
No, that would not be the case.
Well, why else would he have been there? Why else would he have been there if not to participate in this shooting?
That was never put into evidence, Your Honor, as to why he was there. All they could say is he was there. He's was all for in the case at in point, not including the gang stuff. All they could say is that he was there. They couldn't say he was a leader, that he had somebody shoot Mr. Washington, that he shot Mr. Washington. We don't know.
This is Justice Clark, but isn't the statement that you're making one of the reasons that the state would argue that gang-related evidence then becomes admissible because the fact of gang membership and other connections like that, again, is just one more thing that a reasonable jury could take into account.
The jury, one of the reasons that we had the motion to eliminate and one of the reasons that the Court of Criminal Appeals went ahead and reversed it, and then the court has also mentioned it here, is it was so prejudicial. Matter of fact, I think somebody said that it was over the top, that it didn't come about whether or not Mr. Reynolds committed the murder. It was whether or not what the gangs, about gangs. It all became about gangs. It came about the history of gangs, which violates 402, 401, because it wasn't a part of the case. This case was not about gangs.
This is Justice Kirby, Mr. McDougall. Did you at any point make an objection, either motion in limine, motion for new trial, that was specific to the evidence that is at issue in this appeal, the somewhat extraneous evidence of the history of gangs and the evidence that's not particular to your client's identity in the crime, but just contextual history about gangs? Did you ever make an objection at any point to that particular type of evidence, or to evidence of Mr. Jackson's crimes? Did you make a specific objection to either of those?
Yes, Your Honor. That's what the motion in limine was about. It was about not only the history of gangs was brought in, but also Mr. Reynolds' gang ties. The pictures, those were all put in to evidence in the motion in limine, which we objected to. We objected to all of that coming in because it would be more prejudicial than probative in this case.
Let me clarify my question. I'm not asking whether you made a broad objection that would have encompassed everything. I'm asking whether you made a specific objection to that evidence at any point.
It was part of the motion in limine because that was the evidence that was put forth. Everything that we're objecting to here and that this Criminal Court of Appeals looked at,
is that a yes? Is that a yes or is that a no? Did you make a specific objection? Okay, yes. What did you say or write that was specific to that evidence?
In the motion in limine, and then was broadly introduced in the before the trial and everything. But in the motion in limine, we had gone over the reasons why that the pictures shouldn't be in, because they're more prejudicial. They had nothing to do with the case, and the judge Judge Steelman had addressed that. So I mean, he addressed it, and what the Court of Appeals went over. If the court looks at what the Court of Appeals said The Court of Appeals had gone over the testimony, had gone over the fact that that we had objected to that and everything. For the gang evidence, whether or not it was 401, 402, we had objected to all of that, whether or not the gangs, whether or not the membership should even come in at all. The state had originally stated the only reason they wanted the evidence to come in for gang membership was the fact that it connected Mr. Reynolds to Mr. Jackson, because they were both members.
Did you ever object to the evidence on Mr. Jackson's crimes?
Yes, and the judge had actually ruled that the state couldn't bring in the fact that Mr. Jackson was originally arrested on robbery, and basically said you could come in, you could say that you got the gun from Mr. Jackson, you can't mention that it was a robbery where somebody was shot, and that was upheld. That never came in, so that objection was specifically kept out. We managed to keep out the fact that the gun was used in a robbery whenever Mr. Jackson was arrested, where they got the gun from.
Mr. McDougall, this is Justice Page. I believe I hear you conceding that the state properly proved to the jury that both Mr. Jackson and Mr. Reynolds were in the same gang in order to show the connection to the 45 high-point pistol used in the murder, correct? You concede that?
They did go ahead and show that Mr. Jackson and Mr. Reynolds were part of the same gang.
Do you concede that was proper to show the connection between the murder weapon and your client?
No, Your Honor, because that even though they're part of the same gang, that didn't show they knew anybody, or show how Mr. Jackson got the gun, or did Mr. Reynolds have the gun. I mean, all they showed is that was the murder weapon.
Well,
it never showed a connection to Mr. Reynolds and the murder weapon, and which they needed to do.
Well, it was clear that the 45 high point was used in this murder, correct?
Yes, Your Honor. The forensics shows that the murder weapon was that weapon.
And it was also found in the possession of Mr. Jackson when he was arrested on the robbery charges, correct?
That's correct. And Mr. Jackson couldn't have been the murderer because he was in jail at the time.
That's correct. But the state's theory was they were entitled to show, for, if you call it identity purposes or completing the story, that Mr. Jackson was in possession of the murder weapon and that Mr. Jackson and Mr. Reynolds were connected by being in the same gang, right?
Yes, Your Honor. But we also was also shown that there's like 1,000 people in the gang, and that there's nothing to show, because they showed all these pictures of the gang, of Mr. Reynolds and the gang, but never showed a picture of Mr. Jackson and Mr. Reynolds in the gang. They didn't show any type of connections where they knew each other. They didn't show where Mr. Jackson and Mr. Reynolds had any type of connection except for the fact they were in the same gang.
But under 404B, though, isn't it responsible for reviewing trial court to rule that the probative value was not outweighed by unfair prejudice in that scenario?
Yes, Your Honor.
Okay.
However, we would state that being the fact that even then, one of the reasons we renewed the objection was there was a gang shooting that morning, or the night before, and that had been in all the papers and everything. And there had been a lot of gang shootings, which is one of the reasons we didn't want to have it in. Just
In
the
the,
mention of gangs would hurt Mr. Reynolds.
In the Court of Criminal Appeals opinion, they opine that it was proper for the gang membership of Mr. Jackson and Mr. Reynolds to be shown to the jury. Do you agree with that?
They did opine to that. I am defending their decision, so I guess I'd have to say that for that reason, they could go ahead and show a connection there. Yes.
They also said in their opinion that the gang validation form was properly submitted to the jury. Do you agree with that?
It was, Your Honor, but of course we didn't want the gang stuff to come in the first place because there's no reason for the gang to come in, but for the fact that the state was trying to go ahead and show that Mr. Jackson had it and this was a gang gun or something else like that, which the Court of Appeals also brought up and said that was prejudicial, very prejudicial, that this was some sort of gang gun. And once again, instead of going to the evidence of the case, goes to bring up fear of gangs and therefore taint Mr. Reynolds with that. Why they use Sleepy, why they brought in all the gang signs, why they got the history of the gang signs.
Well, the Court of Criminal Appeals also said the photograph of your client with other gang members making gang hand signs was properly admitted. Do you agree with that?
No, Your Honor, because that had nothing to do with it. It's character evidence. And there should not have been any character evidence brought in because there's no character evidence introduced as to Mr. Reynolds.
What is your response to the question I asked Ms. Redding about the closing argument of the state mentioning gangs and stopping gangs? Does that have any impact on what we're doing with this case?
Yes, Your Honor, and that's one of the things that the Criminal Court of Appeals had brought in, and one of the reasons we didn't want gangs to be in here. It didn't come to, did Jeremy Reynolds shoot Mr. Washington? It came up to, you have to stop the gangs, and that's one of the reasons we did not want gangs brought in.
Mr. McDougall, this is Justice Bivens. Where in the record did you object to that?
Object to Sleepy?
To the closing argument by the prosecution.
I did not.
You didn't object at the trial, did you?
No, Your Honor, I did not.
You didn't raise that as an issue. You didn't raise that as an issue in your appellate brief, correct?
No, I did not, Your Honor.
So you can't really argue about it now, can you? Didn't you waive any objections to closing argument?
If the state can go ahead and bring up the fact that they didn't bring up that the evidence that I objected to and my argument for the Criminal Court of Appeals, and didn't bring it up then, but bring it up now, that's why I'm bringing it up. And I'm defending what the Criminal Court of Appeals brought forth in that. It was part of the evidence. It's something that they considered, and I guess something that the court can consider. But if the court can go ahead and consider that, well, you didn't object and your objection was too broad, then I believe that would be something that this court can consider as well. Whether it be a plain error, under plenary, I don't think that the court can go ahead because I did not bring it up in my briefs, but I think in plain error, the court can if the court knows about it and the state brought it up. And when the Criminal Court of Appeals brought it up. So it's before the court there because they brought it up. And that was, I think it may have been something that was argued in for oral, but I can't recall that for sure.
Well, even if it's plain error review, how do you win on that? How does this fall within the elements of plain error review?
Well, Your Honor, I did what I'm going by is the fact that in my objection, I objected to anything gang coming in. The court went ahead, we went over everything evidence was going to come in and the motion in limine, and the court basically ruled what could come in and what could not come in. So that was all encompassed in there. I didn't want anything in gangs to come in because I felt it had nothing to do with the case. There was nothing in the case that had anything to do with gangs. Mr. Washington was not in a gang. This was not a gang hit as far as we knew. All we knew is Mr. Washington was shot and he wasn't part of a gang. Mr. Reynolds was part of a gang, but I think that would be more character evidence than anything probative was our thing. Now, of course, the state had brought in the fact that, well, these guys are part of a gang, but never showed any connection other than that. Didn't show a picture of them. Didn't have somebody come in and testify that they knew each other. There was nothing of that.
Mr. McDougall, I'm sorry, go ahead, Justice Lee.
As I understand it, you didn't want gang evidence. So why are you saying they didn't produce this gang evidence to connect when you said any of that was improper?
It doesn't have to be gang evidence, Justice. They just had to show some sort of connection other than the fact the only thing they could show was the gang. That's why I wanted to keep it out.
Okay, thank you.
Other than that, they had no connection. That's what I'm saying. They should have had some other connection other than, well, gee, these guys have been in the same gang. They have to know each other. A lot of it is assuming. They assume that, well, he was lying in wait. They're assuming that they knew each other. They're assuming a lot in this case, and the case itself cannot be done by assumptions. It has to be by proof. The proof itself didn't show anything in that. And looking at the light for best for the state, they show that Mr. Reynolds was shot. He was shot with the same type of gun that was in Mr. Washington's possession. They show a light colored car driving away from the gun thing. About 8 minutes later, three people come in, dump Mr. Reynolds onto a hospital gurney and leave. That's what the evidence that's what the evidence shows. It does not show that Mr. Reynolds conspired with anybody. It does not show that Mr. Reynolds had a gun. It does not show that Mr. Reynolds told somebody to shoot somebody. It didn't show that no aid was rendered. None of that was in the trial. The only thing that the state could show is Mr. Reynolds was shot with the same type of gun, and that they figured he was in the white car.
This is Justice Bivens again. So are you saying that a case for premeditation cannot be made by circumstantial evidence alone?
No, I could not. No, I do not state that. But I think that there has to be some evidence to show that. The state was originally going on the fact that he was shot so many times, and the Criminal Court of Appeals addressed that. They addressed the fact that just being shot a lot of times is not enough. You have to show something where this was planned. I mean, and I know that the court will go back to the fact that in a blink of an eye, there could be premeditation. But in this case, there's nothing showing us that. There's nothing to show that where this was planned. Now they can say, well, they came in, but they just coming, if looking at the light most favorable to the state, they still can't say just the fact that they appeared there that they meant to shoot Mr. Washington. All they can say is they came there. There's many reasons that they can come there, but the state has to show for premeditation purposes that there was a plan, somebody that Mr. Reynolds planned on or was part of a scheme to premeditatedly kill Mr. Washington. Now, there was a question that the Court of Criminal Appeals brought up and said, well, what if it was a felony murder? But however, I mean, a robbery, because that was brought up. But here's the problem. They never charged him with felony murder. So they can't go ahead and convict him of felony murder if they did not indict him for that. The only thing we're looking at is premeditated first-degree murder. And in this case, they have to go ahead and show the elements. We argued, the Criminal Court of Appeals agreed, they never showed that that Mr. Reynolds had planned this, had been involved with it, or anything else of that nature. They showed his identity, I believe, but they didn't show where he had committed, where the murder was committed.
You spent most of the time in your brief arguing there was no proof of identity. Are you now saying there was sufficient proof of identity?
No, Your Honor. I'm saying that and looking at the light most favorably to the state, that they showed that Mr. Reynolds was shot. He was shot with the same type of gun. And if a rational jury could say, maybe he was shot there and everything, but that doesn't prove premeditation. That just shows that he was shot.
Does it prove identity?
If they can go ahead and connect the gun, they can. But part of the problem that we have with that is the expert cannot say, yes, this is the gun, because she was able to show that 100% that the, 99.9%, that the high point that shot Mr. Washington was the gun. She was able to say, that's it. She was not able to say that as to the Glock that shot Mr. Reynolds. She was basically able to say it's the same type. But if you look at the evidence, she testified that the markings are the same on all the guns. And so she could not go ahead and say that gun specifically was the one that shot Mr. Reynolds.
But Mr. McDougall, to be fair, an expert can never match a Glock because of the polygonal markings are the only thing they can look at, and they can just show a type of gun, but not a specific weapon. Isn't that correct? That
is correct, Your Honor. However, that's part of the things that they have to prove that it wasn't another Glock that shot him. And that could have happened. He could have been shot with another Glock.
Well, did you have an expert witness testify that it could have been another Glock or it was another Glock?
No, Your Honor. The TBI witness that testified she couldn't say that, and she did testify that she couldn't say that gun was the one that shot it because of the waffle design.
What I hear you saying is that her testimony was speculative.
Yes,
It's not
that
probative.
basically,
What, was there a motion made to exclude that testimony based on just the lack of probative value?
no, Your Honor.
Okay.
And the state can't infer facts, because I mean, a lot of what the state has tried to do is infer facts. Well, they waited and they didn't give aid. And that is something that that you can't do in a trial. They have to prove beyond a reasonable doubt. And that's one of the questions that the Criminal Court of Appeals had, was they didn't prove beyond a reasonable doubt. That's why they sent it back. The question that the Criminal Court of Appeals was looking at is, if they couldn't go ahead, if beyond a reasonable doubt they couldn't prove it, if all they did was prejudice the jury, and that's what the Criminal Court of Appeals found, was the jury was so prejudiced by all the gang evidence that came in, that's what they didn't look at the evidence. They didn't follow the dictates of the court. And I would submit to the court that without the gang evidence, they don't get a conviction, even with everything they did. If they're just basically going upon what they have there, they don't get a conviction. They convicted Mr. Jeremy Reynolds because he's a gang member, and they brought in all the stuff that said how bad gangs are. They have in the newspapers how it is. They say, stop it. And that's one of the reasons, stop the gangs. Stop it right here, which means go ahead, even if he's not guilty, stop the gangs. And that's not the purpose of what the of the trial. The purpose is, did he kill Wendell Washington? And I had averred to the court that they did not go ahead and show that the state. They merely made the jury afraid with prejudicial evidence with the gangs. And so that's what that's our argument. That's been our argument since the beginning. This gang stuff should never have come in. That's what tainted the jury. And so Mr. Reynolds did not get a fair and proper hearing on this. And that's what he's asking for now. So we're asking that you do not reverse the Criminal Court of Appeals, and that you uphold it and give Mr. Reynolds a chance at a fair trial. Thank you.
Ms. Redding on rebuttal.
Thank you, Your Honor. I'll be brief. Just addressing the defendant's premeditation argument. The state's argument is that there are facts from which the jury could infer premeditation, that there are facts from which the jury could find that the defendant was the perpetrator, and there are facts sufficient for the jury to find the defendant guilty of first-degree premeditated murder, either as the shooter or under the theory of criminal responsibility. The defendant was not just merely present when this occurred. He was an active participant, and his contact wound eliminates the possibility that he was.
Ms. Redding, this is Justice Clark. Do you believe there are still sufficient facts in the record to show premeditation if all gang evidence were removed?
I think that the state's position has never been that the defendant committed the offense because he was in a gang. And the state's position has always been that the evidence is sufficient based on the testimony that we have about the offense, about the gun, about the shooting, about the wounds, and the gang evidence was relevant to the extent that it connected the defendant to the High Point pistol. And in order to get that connection between the defendant and the High Point pistol, there had to be the connection to Mr. Jackson. So the gang proof is sufficient to show, the gang proof is necessary to show that connection, to bridge that gap for the jury. But the proof that shows premeditation is the proof about the wounds, about the circumstances of the offense, about how what the defendant did when he arrived at the victim's house. What shows premeditation is not the defendant's gang membership.
Ms. Redding, this is Justice Kirby. Let me ask you some specifics about the gang evidence, in particular about the evidence that the Court of Criminal Appeals found particularly prejudicial, the extraneous evidence about gang history and so forth. The Court of Criminal Appeals opinion says that the defense counsel objected to Investigator Penny's describing the history of the gangs and the shoot and ask questions later, and said, we're just going far afield, really, of his identity as a member of the gang. And that's what the Court of Criminal Appeals said was prejudicial. And they found described it as prejudicial in light of the prosecutor's argument, calling the defendant sleepy and that sort of thing, highlighting it in his. I want you to address specifically, under those circumstances, why this defendant is not entitled to plenary review on that issue.
Well, I believe the Court of Criminal Appeals said that the defendant objected when Investigator Penny testified about the shoot first and ask questions later stance that the gangster disciples had, but noted he didn't actually make an objection to the historical information about the gangster disciples.
Okay, well, we'll have to look to the record. The Court of Criminal Appeals says defense counsel objected to Investigator Penny's describing the, quote, history of the gangs, close quote. It obviously doesn't have a record reference in there, and I have not read the record. But tell me why he's not entitled to plenary review on that issue.
I think it's the three steps. First, the motion in limine was too broad. Second, that the motion for new trial did not reference the specificity Investigator Penny's testimony about the history of the gangster disciples. And finally, the defendant's brief does not talk about Investigator Penny's testimony about the history of the gangster disciples. And the reason that the state didn't argue waiver in the Court of Criminal Appeals was because the defendant didn't raise these issues. And if the defendant doesn't raise the issues, the state can't make a waiver argument preemptively. And it's those combinations that mean that the Court of Criminal Appeals had an obligation to conduct plain error review, not plenary review. And so it's a combination of those three factors.
Okay, thank you.
If there are no further questions, the state respectfully asks this court to reverse the decision of the Court of Criminal Appeals and uphold the jury's decision to convict the defendant of first-degree premeditated murder. Thank you.
All right. Thank you, counsel, for both parties. We appreciate your participation here today. And this time that concludes our argument docket for today. Mr. Clerk, if you will adjourn court, please.
Your Honor, this